Some viewers may find the following video disturbing. Viewer discretion is advised.
That's irrelevant.
Not to me it isn't. Maybe to you. Not to me it isn't.
If he wouldn't have been going so fast, he wouldn't even hit the van.
Okay. Thank you.
Hey, Chris.
Yes, sir.
He thinks that this is a
here.
cocktail hour.
Not while the court was in session.
Okay, but your phone was still going off and you were still distracted by the phone.
No, that is untrue. That is totally untrue. And that has nothing to do with the
Yes, it
sentence.
does have something to do with it.
Do you have anything you want to tell me in regards to this sentence?
Yes, I'm
before I
involved
vote
with
sentence?
mistrial because I don't
Denied.
believe it.
Hopefully someday you'll think about that. Get him out of here. I'm done.
That's going to cost you 30 days in the county jail for contempt. Cuff him if you got the cuffs. You can either make life easy or you can make life hard.
I already ruined my life.
That's 60. You want to go for 90? That's 90 more. That's 180. That's 306.
Now I gotta come here and my life up. You.
No, and stop.
How many days you wanna give me now? Are you sir counting?
No.
Yeah, I'm at about a year right now in contempt, so.
Old ass face, man.
I'm sorry. What you say? Come on, speak your truth, Mr. Osborne, because we're tired of the case too.
You're going to be held no bond, sir, until further order of the court. Thank you.
Are you kidding me?
Yeah, no, I'm not kidding you. That's the truth. You're not going anywhere. That's the truth. All right, thanks. All right, Suzanne
My
Walt.
charge was battery.
Oh, wow, I know, man. But that's the way life is. What did he say? Whoa, whoa, whoa. Bring him back. Whoa, whoa, whoa. Bring that guy back. Bring him back. Whoa, 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 whoa. Hey, bring that guy back.
You want him back, Joe?
Yeah, I want him back right now. So what did you just say when you walked away?
I called you a because you're...
Woo.
That's
Did
not
you?
my charges I had yesterday.
Okay, hold on a second,
I had
sir.
a battery charge.
Sir, this court is inclined to hold you in contempt of court, and I want to know from you, give me a reason why I should not hold you in contempt of court.
I don't see a reason why you shouldn't, because there's not a reason this should be here.
Okay, sir, I find you in contempt of court for using that type of language with the court you just used, and before I pass sentence on you, I'm going to ask you if you have anything to say before I pass sentence.
I apologize, I was out of line. I'm just upset because this is not what I was charged with yesterday.
Okay,
I
sir.
was charged with a battery.
I accept your apology, and I will sentence you to 60 days in the Broward County Jail. Thank you.
Can I take the back in?
All right, sir, hold it. Come on back. Come on back, sir. Sir, I'm inclined to hold you in contempt of court again. Would you like to tell me why I should not hold you in contempt of court for the last thing you just said?
I asked if you're allowed to do that for me.
All right, sir.
Talk.
I find you in contempt of court for the second time you said that. Do you have anything else you'd like to say in mitigation of the second sentence I'm about to hand down?
I was just asking my attorney if he can do that.
All right, sir, you have nothing. I'm going to send you to another 60 days to run consecutive to the prior 60 days. So now you're up to 120 days in the Broward County Jail. Do you have anything else you'd like to say?
Nah.
All right, sir, thank you very much. You're done.
I didn't even know you can do that.
All right, thank you.
Because he has a big mouth, I'm awarding you a judgment against him for $450. Now you can take your blue shirt and go outside, and I'll deal with the rest of them.
That's funny. Just because he's short.
Maybe. Maybe. He's your friend. You said it.
You said it first. You said he's short.
$450. Bird, put him out.
Oh, sir, excuse me.
No, just him.
Okay, sir, you can step in.
450 out.
Round one would be 10,000.
Are you serious?
I am serious. Adios. Come back again. I believe I heard you saying to...
Yes, I did. I'm not going to the...
I believe you... Did you say me?
Actually, I
Did you say that?
Yes, sir, I did.
Oh, you did say that?
I'm not
I find you in direct criminal contempt. 30 days in the county jail.
I might be penalized if I don't sign.
I'll have you thrown in jail if you don't. Does that sound like a penalty? Don't challenge the authority of the court. Sign the order. You're ordered to do so. If you don't, it's contempt of court. You're not under duress, but you are under court order to sign the order. You're in contempt of court.
Okay.
The maximum penalty for contempt of court is 30 days in jail and a $500 fine.
Don't even try it.
Don't even try
Alan,
it.
Get down there. Sir, I'm going to find you in contempt for interrupting the court.
So is it not possible to amend the drug testing, Your Honor? Is the different? Is it just?
Mr. Jackson, stop talking.
I can't hear. I'm just seeking clarity, sir.
Mr. Jackson, stop talking.
I'm not talking, sir.
So, see, it's that attitude that's the problem. So, what I'm going to do is I will. You need to be quiet.
I am. Sir?
Mr. Jackson, let the judge talk.
I understand. I'm not sure if there was a mute or something. I'm just making sure. I understand.
Okay, so you don't have to respond to everything that's said. You don't have to get the last word. That's not.
I'm not trying to. My life is on the line here. That's all. That's all I'm.
Okay, you know what? You know what? Put some deputies at that door right now. Because apparently he doesn't want to listen to his attorney. He doesn't want to listen to me.
Sir, I'm just seeking clarity on the matter. That is all. I promise. I'm a black man in the system, just trying to fight for his freedom. That's all.
Okay, so am I. So don't even try it. Don't even try it. Don't even try it.
Don't even try
Alan,
it.
get down there. Get down there. Sir, I'm going to find you in contempt for interrupting the court.
I'm not
Mr. Brown, if you've got somebody down here, he can come in, he can see me in person. We'll wait for a prosecutor to get down here and I'll deal with this in person. I'm passing it right now.
Your case is dismissed.
No, ma'am.
We are done.
No.
Court is adjourned.
We are humor me
done.
to hear the story, please.
We are done.
No, I'm not going to do that.
Oh, yeah,
no.
you are.
Well, then there's a breach of contract, right? Because you told me you were going to hear the case.
I heard my
You did not hear. No, I won't go. No.
The case is over.
I'm not going.
Technically leave and you guys could issue a warrant as long as I don't return. You can kiss my. This is.
You know what? No. I'm going to tell you what. You don't come in. You don't. Okay, that's contempt. That's 93. Keep going. That's another 93. That's another 93. That's another 93. That's another 93. That's 6 93s consecutive.
She just told your stupid ass.
Mr. Haywood.
No, you didn't. Bond revoked. We're done.
Judge
Bond
Simpson,
revoked.
I'm unable to continue.
He will sit. This matter is adjourned to September 1st. Bond revoked. I'm done. You go talk to your client. He'll never address that court this way. His bond is revoked. You're still his attorney. Motion denied.
Thank you.
What did you say?
I said
bye. Case is dismissed. We're done.
Your Honor, I have a countersuit.
You're done. You're done. If you don't know where you are, that's your problem. Goodbye.
The case go forward. So now we can have the dispute discussed and figure out what issues are there for trial and what issues might resolve.
I mean, what are we disputing? You're already ruling in their favor now, and you're probably going to do it in the future. So what's the point? What is all this for now?
Excuse me?
Sit up here and let him
Excuse me, Miss Edwards, what are you talking about? Are you claiming that you don't understand? You just wait a minute. You wait a minute.
21 days for me, you would have threw my.
Stop talking.
Man,
Stop talking. Okay, I can see that something is going on with her, but she's alleging now that somehow I have made a ruling in favor of them, and she doesn't like it, so she blanks out. So you have to come back with your camera. We're in a hearing. If you do not, there you are. Thank you. I have made a ruling on a preliminary matter in this case.
Yeah, I heard you.
I don't even understand. No, first of all, you can't overtalk me.
I will give you
no, stop. I will give you a chance to talk when
I don't have nothing else to say.
Stop.
I don't have anything else to say. You stop. I don't have nothing to say.
Stop. You cannot overtalk me because we can't record it. It's a process. So you have to stop interrupting and being so absolutely rude and condescending. And if you leave, this case is dismissed. Ms. Carter, let her know if she leaves, it doesn't come back on camera, I'm dismissing the case. If you want your case to go forward, you have to stay with the court. You cannot talk over anybody because we cannot record this on Zoom. That's why you can't talk over. I will give you a chance to speak like I give everybody.
Dismiss the case, like you threatened.
And you
Dismiss
do
the
not
case. I'm good.
interrupt. All right, she doesn't want to participate in the case.
Yeah, dismiss the case. She was gonna do it anyway.
Yep, now she's making false claims against me. Mr. Mubarak, she's looking like she's voluntarily abandoning her case. You move to dismiss?
Yes, sir. We move to dismiss.
Okay, case dismissed. Please file an order.
Yes, sir.
Wait on. Oh, prejudice motherfuckers.
Okay, you're in contempt of court. You're going to be brought into the court. Is she out there? Bring her in.
Your Honor, she's at 14-1.
She's at 14-1? Okay, I'm going to schedule I want this recorded, and I want to schedule a contempt of court hearing. So make sure you file a copy of this record. Once we have a copy of the Zoom recording, schedule a contempt of court hearing in 14-2 in person. Failure to appear will also be contempt of court. This is criminal contempt of court, and we'll send out a notice once we have that. As the order will say that this case is being dismissed as the plaintiff voluntarily abandoned her claim. Send out a summons to appear in court. Failure to appear will end up with a bench warrant and another contempt of court for failing to follow that.
Back into the lockup, sir. You're in contempt of court and you're going to jail.
What am I doing? You're in contempt of court.
For what? Courtroom and being disrespectful. This is
I didn't mean it.
Yes, well, I don't care whether you meant it or not. You said it to me, so you can go to jail for a while and you go back outside.
I'll go to my car.
You're going to jail, sir. You and I are going to talk about this a little later this morning. This is a public courtroom. We're not sitting around the kitchen table and you don't get to express your opinion about what you think about the veracity of the case.
Judges and their courts are like kings and their castles. They rule over them sometimes with an iron fist and sometimes a little leeway. But their role is to maintain the order of the courtroom so justice can be served. And from what you have just seen, and as we know, judges don't put up with acts or behavior which can bring the courts into disrepute. And they have a way of dealing with such behavior, and that word associated to that way is called contempt. It allows the judge to make sure that everyone knows that the judge, like the king, rules their court. So it is shocking when you see a judge throw away the power of the judge and allow themselves to be ruled over by a defendant, bow down to them, and be dominated. To lose control of the kingdom, and we are about to see Tarzan isn't ruling the jungle anymore. Judges can never afford to be weak, especially in the public forum of YouTube. So let's go see a judge set a new precedent in bowing down and giving up the keys to her castle.
33rd District Court, the state of Michigan versus Bradley Peterson. All right. And so today is the date scheduled for a probable cause conference in this matter. And counsel?
Your Honor, I had the opportunity to speak with Mr. Peterson in the breakout room, and this is something that the court may be aware of, and I am not. Mr. Peterson had recently come out of being incarcerated for the purposes of these proceedings. He got out on bond, and that was arranged. Mr. Peterson and I had discussed a number of things in the breakout room. We discussed going forward with strategy in this case, and Mr. Peterson had informed me that he had filed a motion with the court to remove the judge from this case. And regardless of whether that motion had been filed or not, or whether he intended for such a motion to be filed, I advised him that I was not comfortable with doing so and that I did not agree to do so for the purposes of this case. And as such, him and I discussed that this was going to be a stopping point in going forward with representation. And as such, we parted amicably. And at this time, I would ask to be allowed to recuse myself from this case, Judge.
All right, so counsel, you are asking to be removed from this case because Mr. Peterson filed a motion on his own and not with discussion with you, and you're not comfortable with that motion.
That is not the sole reason, Judge. Mr. insisted that the only way that he would be comfortable with me representing him in this case, is if I continued and persisted with this motion. I do not agree with the motion that he is filing, and he said that he would prefer to go on his own if I would not go forward with this motion in his behalf. And we had a civil discussion about this, Judge. We did not have a fight or anything. I want to make that clear. Mr. Peterson and I have a good relationship speaking-wise, so I'm not trying to cast aspersions on him at any point. I want the record to reflect that. But this is an impasse that we have reached, and that is the reason I have brought this to the court's attention.
All right, the court will note that there was a motion that was filed today asking for this court.
For the videotape, hearing a bell and charges.
Okay, we don't have videotape. You can request a transcript, certainly. Yes, you can certainly request a transcript.
Yeah.
You don't need a motion for that. You can request a transcript without a motion, just so you know.
Okay, well, we did it over Zoom, so I just assumed that you'd have a videotape of it, not a transcript of the 7th, January 7th, when we had a bail bond discussion and charges of trespassing and assault in the city of Woodhaven. We did it over Zoom.
I understand we did it over Zoom, but we don't, that was not recorded over Zoom. It was
just on transcript.
Recorded on our transcript.
Okay, well, I'm gonna have to file a motion for that, I guess, because I don't.
No, sir, what I'm saying is that you don't need a motion for transcripts. You can just request the transcripts.
Okay, yeah.
There's a fee that you have to pay, but it's not a motion.
Okay, yeah, I request that. Also, I request on the Michigan Court Rule 2.003. I believe it's filed that on the 17th on Friday or something like that. So
okay, hold on, just a moment. Okay, well, counsel, I will allow you to, I will grant your motion to terminate representation specifically as far as moving forward. But counsel, I would just, if you can just stay on these proceedings.
Oh, of course, I would sure, yeah, I have no problem.
Let me finish, please.
I'm sorry.
To advise Mr. Peterson appropriately if he's getting into some territory he shouldn't be getting into, okay?
Of course, Judge.
Thank you. All right, and so, okay, that's what this one is. Okay, so this seems to be, so the motion you filed today, sir, is regarding the Zoom video that does not exist, but the transcripts you can certainly request, correct?
Yes.
That's all of this one, okay.
Yeah.
So I'm just going to note, defendant's motion for Zoom transcript denied, as it doesn't, Zoom video denied, as it does not exist. You filed something on January 17th, and you're requesting our 2.003 to dismiss, qualify the judge as follows. Filed the motion in good faith. Fair bond conditions and restrictions to stop U.S. public protests at City of Monument Public Schools are biased favors given to plaintiff. Okay, well, sir, I can tell you that that's not, that's a condition this court put in because that's what's alleged as a violation. So to protect the complaining witnesses, that's what the court put in. Just as in any assault case, sir, I put a no contact provision in. And so that is why I did that, not because there's any bias at all.
Well, if you keep
not
reading,
at all.
If you keep reading, Your Honor, you'll see that the U.S. Federal Court, Judge Grant, Your Honor, because the city of Woodhaven tried to put a PPO on me, specifically told them, case dismissed, that he cannot violate my constitutional rights.
Okay,
now, and I believe that's the issue.
Oh, hold on, please, just one moment. I understand that you think that that's the issue. I'm not trying to violate your constitutional rights. What I'm trying to do is that there is, right now, that there's a complaining witness. There are allegations, and so the court, as condition of bond, has put certain parameters and conditions of bond on. Just as, like I just stated, just as if there is an assaultive, somebody with assault and battery or domestic violence, they're not allowed to return to the home or wherever the victim lives. They're not allowed to return to the victim's place of employment. They're not allowed to contact the victim. Those are all conditions I put in. Somebody with disorderly conduct, I put certain provisions in there, whether they can use alcohol or not use alcohol, whether they have to use testing or not testing. It's not intended to violate any rights under the U.S. Constitution. The purpose is for protection of the complaining witnesses and protection of society if this court deems necessary.
That's if somebody violated a law. I haven't violated nothing.
Sir,
I'm with
the allegation is that you assault or resisted, obstructed a police officer causing injury and trespassed.
That's just an allegation.
You're correct. But as a condition of bond, there are certain factors the court has to take into consideration when assessing bond, and the court has judicial discretion to assess bond conditions. That is what this court did. I didn't place you on house arrest, told you couldn't move anywhere. I didn't do any of that, sir. I simply put forth conditions relevant to the allegations therein. And sir, I'm very much aware that there are allegations only.
No, you need to read the whole thing, or just one. I got like 15 issues in there.
15 issues.
Yeah,
okay,
you need to read the whole thing. Also, Your Honor, I publicly protested today in front of your court.
Okay.
But none of your police came out to arrest me because that's my constitutional right to do. I'm not ignorant of my constitutional rights. I'm not ignorant. A judge told me a long time ago, ignorance of the law is no excuse.
Right.
And so I studied a little bit. I don't know a lot, but I know my constitutional rights. I've done read your European Constitution over and over again. Actually, I wrote one of my own. If I followed your white laws.
Oh no, here we go. The race card. This guy actually had me thinking that he was a maverick, and has shown that the man on the street doesn't have to study at university to stand in a court of law to argue his points properly, relevantly, and what seems to be successfully. But all of that immediately gets tipped over, and all of that, well done, mate, spills down the gutter, when now he segregates the law into a white colonial apartheid.
I followed him. Then you stomp on me when I followed your laws. You've been doing this for hundreds of years. You know, Martin Luther King marched, and you guys take dogs out.
Stop right now. I'm not 100 years old, so do not accuse me of stopping at anything.
Well,
let's be very clear on that.
Yeah, well, yeah, don't seem like it.
I'm not 100 years old, sir. Were you interfered with at all while you were engaging in your protest?
My constitutional right? No.
No, you were
I
not.
did at the city of Woodhaven, though, and now you condemning me for it because you restricted me.
Sir, let me be very clear.
I've committed no crime.
I am restricting, I put conditions on for the protection of the complaining witnesses, which is the authority that I've been given with my judicial discretion.
You also took an oath to uphold every citizen's constitutional right to public protest. But you're not doing that.
Sir, let me clarify. Let me clarify something. There is a balancing act that as judges we have to do. So we have you're charged with a crime, right? It's an allegation. We have the protection of the victim and the community. All right. So there's a balancing act that this court has to do. And that is what this court is doing. I have not restricted all of your movement. I have not said you can't put signs up anywhere. You can't go on any public property. I have not done that, sir.
What is so funny is this judge trying to explain that she is not a racist by justifying her decision to implement restrictions, as if informing this clown of why she's fair rather than a racist would change anything about the strategy he is using in playing the race card. She talks about her judicial responsibilities, yet allows her courtroom to be taken over by someone that has played her like a broken fiddle.
No, what I did was I addressed specifically the complaining witness and the victims in this matter. That is what I did, and that is what I have the authority to do that's been given to me by the U.S. Constitution as well. That's statutory authority. Whether you agree with that or not, sir. I understand you don't agree, but that's not a basis for this court to disqualify itself. Let's see what the next one is here. Okay, I don't know what bias favors are. I'm not biased, prejudiced, discriminating against you in any way, sir.
That's your opinion.
And sir, let me just be very clear. The court has not infringed on your First Amendment right of free speech. What it did is it put in protections for the victim in this matter.
I'm the victim.
Which
I'm the
this
victim.
court has every authority to do.
I'm the victim, and you're not recognizing that. I just protested in front of your courthouse and it was okay. You should have arrested me then. When I go to your schools and you wind out, when I go to schools and you wind out,
This is the moment that we can see that the judge has given away control of her courtroom. Instead of shutting him down and warning him of contempt or putting him in the naughty chair like Judge Stevens would do, she instead allows herself to be dominated by the accused. Can you possibly imagine Judge Boyd allowing this type of behavior to happen in her courtroom? I think not.
you should arrest me, but you're not going to. It's
I do
right.
not, let me just clarify. I, as a judge, do not have the authority to arrest you myself.
Well, they don't either. They took an oath to uphold my civil rights, whether they like it or not.
Sir, did anybody arrest you here?
You weren't supposed to. It's my constitutional right to do. Just like in the city of Woodhaven. This is what I'm trying to get through to you. You're trying to say, no. There's allegations against you that you did this, and this. I'm trying to tell you I exercised my constitutional rights, and they violated me. I'm the victim.
And sir, that is everything that will come through discovery and whatnot. At this stage, this is considered pre-trial.
I know what this is.
So
I've been through your system before.
So
also, Your Honor, I've asked if you don't dismiss yourself, I'm asking for another judge to hold.
Just one moment, please. This court, sir, has to take the allegations and there's a process.
Like I don't know it. I know your process. I've been down your roads before. But
I don't know what roads of mine you've been down, sir.
On 15,
You've been here, excuse me.
Excuse me. Unbelievable. She is actually asking the accused if it would be okay for her to talk now. This really is terrible. Can you imagine Judge Stevens asking for permission to finish speaking without it dripping of sarcasm? This is not a case of being polite, but far more the matters of being contrite.
Excuse me. You've been here in this court a number of times as other matters have been disqualified. And you have been treated with respect and fairness. And I believe you even stated that yourself.
That's not all entirely true.
Hold on, sir. I believe you even stated that yourself.
Yeah, but that's not all entirely true. You wasn't here to dismiss the posted signs, was you? You should have been here when the prosecutor dismissed City of Woodhaven posted signs. You didn't show up then.
Hold on, sir. I don't even know what one that is you're talking about.
Well, there was the one that we was going through and postpone. The City of Woodhaven wrote a violation. No, they wrote violations, for posted signs in this case. In other cases. Because I was protesting in the City of Woodhaven. Okay. But on the day that you were supposed to be here to have that case dismissed, another judge took your place. You think I'm sleepy or stupid? I am not. But I'm 15.
Stop there right now, sir. Stop there right now. I don't think you're sleepy and I don't think you're stupid. When was that case? The one that you're talking about that I had another judge sitting for me, when was that case?
Oh my goodness, instead of shutting him down and saying she wasn't at work that day, she is actually going to bend over and give him an actual reason she wasn't there. She's forgotten one of the major rules that Judge Judy always reminds loudmouth defendants when they ask her a question, and that is she's the judge. She's the one that asks the questions, not answer them.
That was, I don't know the exact date of it, but I know the case was dismissed by a prosecutor.
Was that about a year ago, sir?
It was last year.
Last year.
No.
Okay. Well, the time that I had somebody sitting here in my place was because I had to go to Illinois on an emergency basis because my father had a stroke.
Oh, my fault.
So instead of having everything dismissed, I made sure I had another judge here to cover. So do not accuse me of thinking that you're sleepy or stupid. I made sure that there was a judge here to cover it anyway. So whether I was here or not is irrelevant.
The case got dismissed from the City of Woodhaven. But anyway, I'm 15. The defendant under Michigan Court Rule 2.003 requests a hearing by a district court chief judge in case if judge refuses to dismiss herself from this case. I know I have a constitutional right. If you don't dismiss yourself, I have the right for another judge to look at it. This way, it's impartial. It's where another judge can look at it and not just yourself. And apparently, you want to hold this case for a reason. And I believe that you in the city of Woodhaven, the state of Michigan, is in conspiracy. You know what I mean? You guys can say I'm crazy or not, but that's what I'm seeing. Because if you're fighting so hard to keep this case in your court, there's something wrong. Something got to be wrong. You already violated my constitutional right to public protest at the city of Woodhaven because of allegations that I committed assault against the police officer. You guys don't even know me.
Sir, okay, stop right there, please. Just one moment. So, I'm not fighting to hold on to this case. I was assigned this case by the State Court Administrative Office. Now, I'm also elected to preside over cases. So, unless there's a valid reason for this court to disqualify itself, I'm obligated, whether I want to or not, to sit and preside over the matter.
What Judge DeSanto has just done in that statement is to say that he has failed in his attempt to have her recused from his case, and that it is the law that has made that decision for the both of them. And that should be it. That is, if she wasn't all three of the things that this guy needs to win with the race card tactic.
I am the chief judge of this court, and so I don't find that there is a basis at this point for me to disqualify myself. However, you certainly have the right to request the State Court Administrative Office can review that. That is absolutely your right. That's how that gets reviewed.
Well, yeah, I want another judge to look at this, because if you don't want to dismiss yourself from this case, we got a problem right there.
There's not a problem, sir. I have a responsibility. Sir, I have a responsibility. The matter is transferred over to the 27th District Court because the 33rd District Court disqualified itself. Perhaps they sent it here because the other matters that you've had here, I don't know. I didn't ask for the case to be sent here. It's random. I have zero, just as though when I disqualify myself from a case, it gets sent somewhere else. I have no control over where it gets sent. I have no control over what gets sent to me, whether it's from 25th District Court, 28th District Court, 24th District Court, 34th District Court, or the like, sir.
Well,
So, just so you're aware.
Well, I have a history of this 27th District Court in cahoots with the city of Woodhaven. I think the judge, Ken Bash or something like that, he might be up there somewhere. He's retired now. You guys did me the same thing, same way there.
You guys, I wasn't here.
Well, that's what I'm trying to say. Your system, you wasn't here, you're not 100 years old.
It's not my system. It's the system of the country. It's the entire system. You keep accusing this court that I'm 100 years old and I've been oppressing things for 100 years, that it's my system.
Well, I'm saying
I didn't arrest you. That is not
it's your system.
my system.
And regardless, this is your system. It's not mine.
It is yours. It's
not. I'm Native Indian African. I'm not even a citizen.
No?
No, I'm a prisoner in my own country because of you white people.
Oh, even as a non-American, I get sick to death of hearing that same old tune. The race card tactic, ladies and gentlemen of the jury, when they have nothing left to play. Brainless jellyfish can always fall back on the race card. And that is why in court, you can never let the tactic win. Because if you do, you bow down to an adversary that is not only calling you a racist, and that you shouldn't be there, but that the very justice that you are sworn to protect is corrupted, and that they are right. Bowing down to such a person, using the race card tactic, allows the next clown to use it with confidence, and for them to have a shot at winning their motion. All they have to do is quote this very case and name DeSanto's as the judge that allowed the precedent to happen.
Y'all need to go back home where you guys come from.
Okay, sir. Well, let me just say this. All right. You are accusing this court of being biased and prejudiced.
And racist. Yep.
And racist. However, your comment, sir, would seem to suggest otherwise.
Look, why do you raped us, you robbed us, and you murdered us legally?
Stop
Everything
right there.
that you people have done has been legal.
There. It's not you. I did not do that. Do not put that on me. But here's what I'm going to do, sir. I'm going to grant your request. I'm going to grant your request. I'm going to grant your request.
Just in case you missed it, instead of having this clown held in contempt of the court, Judge DeSantos has just informed him that he has just won. After watching so many court cases being presided over by some of the toughest, intelligent, fairest, and empathetic judges on YouTube, it's hard to watch the pathetic, all the times of when judges have shut down sovereign citizens and crazy defendants wailing and whining and acting out, and all of those judges standing firm to uphold the sanctity of the court. We have Judge DeSantos give the power of the court to a criminal defendant that made a mockery of her. I think out of all the thousands of cases that I research, I have never seen a judge bow down to a jellyfish and allow her court and ruling to be directed by the defendant. I wonder what the other judges on my channel would say in how they would have handled this situation and defendant playing the race card. Let me know what you would do if you were the judge in this case in the comments, as I'll leave what I would do.
And this court's going to disqualify itself, and you can figure out which other court's going to handle this matter after the state court administrative sends wherever it's got to send, whatever it has to send. So, because at this point, I am not going to stay here, take the abuse from you and your allegations, which are completely false and unbased. This court, myself, did not do anything that you're accusing me of doing at all. I wasn't even around at that point. So we're going off the record. You can step outside in the lobby. Somebody will give you the next stuff you have to do.
Completely and utterly dominated by a jellyfish of a tactic. So now we know, and so do all the criminals that watch YouTube and this channel, that all they have to do to have Judge DeSantos recuse herself from their case is use the race card. There is no place for weakness in the courts. If there is no justice, then there is only just us, and you never want just us to be jellyfish.
And I'll give you a call, Mr. Kelly. Thank you very much for helping me.
That's all.
Yes.
There'll be another judge assigned.
So am I free to leave, or do I gotta get paperwork or something?
I believe that you're all set, sir.
Well, thank you. You have a good weekend and a good year. Thank you.
Good luck to you, sir.
I don't want to violate none of you guys' law.
What is your plea on
If the
chart?
city
Mr.
if they are the
today is your-
victim,
Mr.
I would like
Martinez,
to
I am in
move
charge
this
of
to
this
a federal
courtroom, and
court.
you're gonna stop
No,
it.
we are in charge of the courtroom.
Marshall, would you show Mr. Martinez the inside of our holding tank, please? You're not going to tell me who's in charge of my courtroom, Mr. Martinez. Go ahead and go with the marshal. That is direct contempt of court. Okay, Mr. Martinez, since you have informed me that I am in contempt of court and that you are in fact in charge of this courtroom, I'm going to go ahead and sentence you today to direct contempt of court. I will give you an opportunity to apologize if you choose to do so and behave in a manner that I consider appropriate for a courtroom. Would you like to do that today, Mr. Martinez?
What would I be
It is a
apologizing?
yes or a no question.
What would I be apologizing
For
for?
your direct contempt of court, sir.
All I was asking was legal questions, ma'am.
I disagree, sir. I'm going to ask you the question one more time. Did you wish to apologize and proceed in a manner I consider appropriate in this courtroom or not? Okay. Direct contempt, I'm going to sentence him to 15 days in jail. Okay, thank you.
And if you want to see a judge take apart a criminal like a fat baboon takes apart a small chimpanzee, then click on the episode on screen now.